Welcome back to the deep dive. This is where we take the documents, the court records, the fine print, and we pull them apart to see what's really going on. We do the heavy lifting so you can get the full picture.
And today we are diving into an organization that, on paper, has a very noble mission. It's called the Army Welfare Housing Organization, better known as AWHO. It was set up specifically to provide housing for veterans and for, currently serving personnel in the Indian Army. A mission built on trust.
It sounds incredibly important. I mean, you have people who've given their lives to service, and this organization is supposed to give them a stable home, usually right as they're transitioning into retirement.
Exactly. It's a critical support system. But our mission for this deep dive, looking at this mountain of legal evidence we've compiled, is to ask a tough question.
Has that noble mission actually been upheld?
Or has AWHO's conduct become a pattern of deep systemic violations against the very people it was created to serve?
And we should be really clear about our sources here. This isn't just a few complaints we found online.
No, not at all. Our source material is a comprehensive body of evidence. We're talking about a collection of adverse legal and regulatory findings from all over the country.
So these are official judgments.
Official judgments from the Supreme Court, from various high courts, from the specialized RERA authorities, that's the Real Estate Regulatory Authority, and from the major consumer forums.
That context is so important for you, the listener, to grasp, because we are not just looking at one bad project that got unlucky in one part of the country.
Right. We're seeing this through the lens of the courts nationwide, and they are revealing the same legal problems popping up again and again across different states, across different years. That points to something, institutional.
And that brings us right to the central conflict, this paradox that seems to define this whole story.
It really is a paradox. AWHO operates on a principle of welfare. It's a no-profit, no-loss organization.
Okay, so they're not in it to make money. The goal is to keep housing affordable for veterans.
That's the idea. And yet, what we see in case after case is the courts being forced to hold them accountable, slapping them with huge financial penalties, basically treating them exactly like any other aggressive for-profit real estate developer.
So that's the big question we need to unpack here, right? Does that welfare status act as some kind of legal shield for them?
That's the argument their legal teams made over and over. They consistently argued that because of their status, they shouldn't be held to the same strict standards of, say, the Real Estate Act, RERA, or the Consumer Protection Act.
And what did the courts say?
Well, the spoiler is a pretty clear no. But it's the way the court said no and the severity of it that's really telling.
They didn't buy the argument.
Not for a second. Judicial forums, from the lowest consumer court to the Supreme Court, have consistently said that AWHO is a promoter and a service provider under the law. Full stop. Their welfare mission doesn't give them a free pass for bad service or for breaking the law.
Okay, let's talk about the scale of these failures, because when you mentioned it to me earlier, that's where the real aha moment happened. What are we actually talking about here?
The scale is, frankly, alarming. We're not talking about a project being a few months late. We have documented findings of chronic, unexplained project delays that range from, say, 1.5 years on the short end.
Which is already pretty bad if you're waiting for your retirement home.
It's terrible.
Yeah.
But it stretches to an incredible 7 years between the time someone booked a home and when they actually got the keys.
7 years.
7 years. Imagine retiring, thinking you have a home to move into, and then spending the better part of a decade waiting. It just throws your entire life into chaos.
And that's not even the most extreme finding, is it? The one that really signals how deep the failure goes.
Yeah.
That was from a high court in Kerala.
Yes. The Chandrakunj Army Towers project in Kochi. This one went way beyond delays or money disputes. This was about basic safety. We have the documentation. The High Court ordered the full demolition and reconstruction of an entire multi-story apartment building that AWHO had built.
Demolition. They ordered them to tear it down.
Tear it down and rebuild it from scratch. Why? Because it was found to be structurally unsound and fundamentally unsafe for people to live in.
Wow. Demolition. That judgment says everything. It moves the conversation from, paperwork problems and delays to an immediate threat to people's lives.
Absolutely. Think about what that means. It implies a failure so total that no amount of repair or patching things up was good enough. The court's only solution was to erase the mistake and start over.
It really forces you to ask, how does an organization dedicated to the welfare of Army personnel get to a point where a court has to literally dismantle the product they delivered?
That's the question. Okay, let's unpack this and see how deeply rooted these problems really are. And the best place to start is where every homebuyer's journey begins, in the fine print.
Your contract.
Exactly. So when we started analyzing the core documents, the brochures they hand out, the agreements, the handover papers, it became very clear very quickly that these systemic problems weren't just, accidents.
They were written into the DNA of the deal from the start.
They were baked into the legal blueprint. AWHO used specific clauses that seemed almost designed to sidestep or even override the mandatory legal protections that the law gives to a homebuyer.
So let's break that down. The first major red flag was about money. They basically institutionalized unpredictability, right?
Yes, financial unpredictability. The brochures consistently had this little phrase, tentative and revisable costs.
Tentative and revisable, which sounds harmless, but in the real estate world, that's a huge problem.
It's a textbook violation of the spirit of RERA. RERA was created to bring transparency, especially on cost. It says you have to declare the final cost, or at the very least, have a very controlled way of making small changes.
So no surprises.
No surprises. But by saying costs are tentative and revisable, AWHO basically gave itself a blank check for future cost increases. The veteran who signed up had no real financial certainty. They were a hostage to whatever costs AWHO decided to add on later.
And it wasn't just the price that was up in the air. The timeline was just as bad.
Just as flimsy. Instead of a firm completion date, AWHO would often only commit to a probable completion date.
Probable.
Just that one word, probable, does so much legal damage to the buyer. The single most powerful protection you have under RERA is the right to get compensation if the builder misses the agreed-upon possession date.
But if the date is only probable, there's nothing to agree upon.
Exactly. They're trying to contract their way out of being held liable for their own delays. It's a clear institutional effort to avoid paying compensation for their own failure to manage a project schedule.
So you've got no certainty on cost, no certainty on when you'll get your home, but surely you knew what you were buying, the actual apartment.
Well, even that was tentative. We found these clauses again and again stating that all layouts, all plans, all specifications were tentative, subject to change.
So they could just change the floor plan after you've paid.
Potentially, yes. And this completely ignores a very strict rule in RERA. RERA's Section 14 is crystal clear. Once a project is booked, you cannot make any major changes to the plans without getting the explicit consent of 2/3 of the buyers.
2/3. That's a high bar.
It's meant to be. But AWHO's unilateral clause was written to let them ignore that. They could, in theory, change dimensions, remove an amenity, alter the layout, all without consulting the people paying for it.
I can't imagine. You buy a place because, say, the layout works for your accessibility needs as you get older, and then they just change it on you and claim they have the legal right to do so.
It undermines the whole idea of an agreement. And that leads to maybe the most audacious clause we found in the source material, an explicit disclaimer that said, and I'm paraphrasing here, all the information in this document is not legally binding.
Wait, what? So the brochure they're using to sell you the project, they're saying none of it is a real promise. Trust us, but legally don't trust us.
That's a perfect way to put it, and it's another direct violation. Under RERA Section 12, the promises and representations a developer makes in their brochure or marketing materials, they are legally part of the contract. They are enforceable.
So that disclaimer is basically illegal.
The courts have found it to be misleading and unenforceable time and time again. It just shows this pattern of institutional bad faith, of trying to separate their public promises from their legal obligations.
And this pattern of evading accountability didn't just stop once the project was, finally built. They tried to wash their hands of it the moment they handed over the keys.
Especially when it came to construction defects. This is where we see the phrase, as is where it is, pop up.
Okay, what does that mean in this context?
In their handover documents, they would include this clause. It basically means the veteran has to accept the property exactly as it is, with all its flaws and with no future recourse.
So if you find a major crack in the wall a month later, it's your problem.
It's your problem. And this is a systematic attempt to get around one of the most important consumer protections in RERA, the mandatory 5-year defect rectification duty.
Can you explain that 5-year period for our listeners? Why is that so critical?
Of course. The 5-year defect liability period is like a non-negotiable insurance policy for the homebuyer. Major construction problems, especially structural ones, don't always show up on day one.
Right. It might take a rainy season or two.
Exactly. It might take time for a settlement crack to appear or for a waterproofing failure to become obvious. RERA says that for 5 full years after possession, the promoter is legally required to fix any of these defects that come to light, free of charge.
And AWHO's as is where is clause was designed to just erase that protection.
To extinguish that long-term legal safety net. It could leave a veteran right at the start of their retirement holding the bag for a crumbling or potentially dangerous home.
And if all that wasn't enough, there's also evidence of them trying to push other burdens onto the buyers prematurely.
Yes, what we call premature burden transfer. Forcing residents to start paying for maintenance and join the housing society long before the project was actually complete or all the amenities were even working.
So you're paying maintenance for a swimming pool that's still a hole in the ground.
Precisely. RERA has rules against this too. Section 11 says the developer has to deliver the basic infrastructure before they can hand over the maintenance burden. This practice just pushed costs onto veterans early, and critically, it also restricted their legal right to form their own residents association voluntarily.
Let's shift to the Consumer Protection Act, the CPA. How do their financial terms stack up against that?
They violated it pretty clearly, specifically the parts of the 2019 Act that deal with unfair contracts.
How so?
The contracts were profoundly one-sided. If the veteran was late on a payment, there were severe penalties, heavy deductions, even cancellation clauses. But if AWHO was late by years, there was no symmetrical penalty for them. That imbalance is the very definition of an unfair contract.
And what if a veteran just got fed up? Say you're 5 years into a delay and you just won out. What was the refund situation like?
It was often punitive. The sources, especially from cases in Panchkula, show that refunds were delayed for months, sometimes even years. And when they finally came, they came with heavy deductions taken out.
But the law has rules on refunds, doesn't it?
It does. RERA Section 18 says if you choose to exit because the developer is at fault, your refund has to be processed within 45 days. AWHO's strategy seemed to be to hold on to the money for as long as possible, making it financially impossible for many people to even consider leaving.
So when you put it all together, this contractual blueprint, it wasn't just sloppy. It sounds like it was strategically engineered.
That's the key takeaway from the fine print. It was engineered to shift every conceivable risk, financial, physical, legal, onto the shoulders of the pensioners while giving AWHO maximum flexibility and minimum liability.
It reveals an institutional intent to use the language of contracts to basically nullify the very laws that were created to protect homebuyers.
Exactly.
So we've established that the problems were literally coded into the paperwork. Now let's talk about how this played out in the real world, on the ground, and how it ended up under the microscope of the courts.
The most glaring failure, the one that comes up in case after case, is just chronic, pervasive delay. It's not an isolated incident. We see courts holding AWHO liable for huge project delays in Panchkula, in Coimbatore, across Tamil Nadu, and elsewhere.
This pattern really confirms that their scheduling problems were, an institutional habit, not just bad luck.
It's systemic. And let's get specific on the timelines, because it's important. We mentioned that extreme 7-year figure.
Right, from the Panchkula project.
Yes, in the landmark case of Alteen Kurl Ajmer Singh, the total time from booking his unit to actually getting possession was about 7 years. Now, the courts do account for some initial time for getting approvals and so on.
Sure, some delay is expected.
But even after discounting for that, the National Consumer Disputes Redressal Commission, the NCDRC, which is the top consumer court in the country, they still found AWHO guilty of about 1.5 years of actionable delay.
A year and a half is still a massive disruption to someone's life plan.
A huge disruption, and we saw similar numbers elsewhere. In the Tamil Nadu RERA cases, projects were being delivered 3, sometimes 4 years late. A home promised for June 2015 wasn't handed over until September 2018 or even later.
And when AWHO was in court, faced with these delays, what was their explanation? What was the excuse?
They didn't really accept responsibility. Their go-to legal defense was to blame external factors. The most common one was disputes with their contractors.
So it's not our fault, it's the builder we hired.
Exactly. Or, less often, they'd blame things like a local mining ban that slowed down material supply or some other bureaucratic delay. They repeatedly tried to argue that this was all force majeure, an act of God, something totally outside their control.
But what's so fascinating here is that the courts consistently and completely rejected those excuses. They said this wasn't force majeure, it was just mismanagement.
Precisely. The judicial view on this is uniform. The court said that a promoter, especially one building homes for veterans, has a duty to do its homework. You have to pick reliable contractors, you have to manage them properly.
A dispute with your vendor isn't an act of God. It's a business risk you're supposed to manage.
The NCDRC said that explicitly. They ruled that contractor disputes are a risk of the trade and they do not qualify as force majeure. So by rejecting this defense over and over, the courts were essentially saying, AWHO, you have failed at your most basic job of project management.
Okay, so if the chronic delays show a failure in management, the next failure we have to talk about. It shows a catastrophic failure in quality control and in safety.
We have to talk about the Chandrakunj Army Towers in Kochi. This is where the story takes a very dark turn.
This is where the judicial hammer really came down.
It's probably the most shocking part of the entire legal record. This comes from the Sibi George case, which was heard by the Kerala High Court. The complaints from the residents were terrifying.
What were they reporting?
Severe structural defects. We're talking visible water leakage through the concrete, floors and walls that were actually showing signs of tilting, conditions that made these brand new multi-story towers unsafe for people to live in.
Unsafe, not just poorly finished, but fundamentally unsafe.
Yes. The court didn't just take their word for it. They brought in expert structural engineers to assess the buildings. And the High Court's final finding was that there were cumulative structural and regulatory violations so severe, so profound, that the entire construction was unsafe and uninhabitable.
The finding wasn't just deficient service anymore. It was a finding of imminent danger.
That's a good way to put it. It reveals a breakdown in AWHO's quality assurance, in their supervision, in their basic construction process that is just breathtaking.
And this led to that unprecedented remedy we mentioned earlier, the order for full demolition and reconstruction.
It's a remedy you almost never see in real estate law. The court ordered the full demolition of the flawed towers, and then it ordered their reconstruction from the ground up entirely at AWHO's expense.
And it didn't stop there, did it?
Yeah.
The court also made them pay for the residents' living expenses.
That's right. The ruling required AWHO to pay for the allottees' rent in another home, their security deposits, even their packing and moving costs for the entire time it would take to rebuild.
So it was a clear statement. The full economic and physical consequence of this negligence falls 100% on AWHO. No ambiguity.
None. It was a complete financial and operational repudiation of their work. And while Kochi is the most extreme example we have, the documents show this quality issue wasn't a one-off. We saw consumer forums in other cities, like Pune, also recording construction defects in AWHO projects and ordering them to pay damages for deficient service.
Let's talk about another area of failure, one that's less dramatic than a building being torn down, but just as damaging for the residents. What happened after the keys were handed over?
This is about administrative negligence, a failure in their post-construction duties. Even after people finally got possession, AWHO was still being found deficient in service because they failed to do the basic legal paperwork.
Like what?
The big ones were failing to execute the conveyance deeds and failing to properly form and register the cooperative housing societies. We see this cited specifically in the Pune Hadapsar project case.
Okay, for our listener, explain why not getting a conveyance deed is such a disaster for a homeowner.
A conveyance deed is the single most important document. It's the legal instrument that officially transfers the ownership title of the property to you. Without it, you don't have a clear, marketable title.
So you can't sell the house or get a loan against it.
It becomes incredibly difficult. You're left in a kind of legal limbo. You live there, but you don't fully legally own it in a way that the system recognizes. And failing to form the housing society properly means the residents can't legally manage the property, collect maintenance, or deal with long-term issues. It's just administrative chaos.
So AWHO wasn't just bad at building. They were bad at finishing the job legally, leaving veterans exposed even after they'd moved in.
It just confirms that the failures are organizational, they are procedural, they extend far beyond the construction site itself. It's an institutionalized failure to follow through.
And this all comes back to that idea of contractual unfairness, of shifting risk.
It does. The Tamil Nadu RERA authority, for example, specifically looked at AWHO's no compensation clauses and called them unreasonable and unenforceable. This confirms that the court saw this as a deliberate, systemic attempt to push all the risks of the project onto the very people they were supposed to be helping. That was the institutional intent.
So we've documented the failures. Now we need to talk about the consequences. This is where we detail the specific and often severe financial and legal hammer that the judiciary brought down on AWHO to force them to comply.
And they had to. The courts were not gentle here because the pattern was so clear.
Let's start with a really big precedent-setting case. This is the finding from the NCDRC, the top consumer court,
Right.
which was later affirmed by the Supreme Court. This is about the Panchkula project.
Yes. The case of Altinkrul Ajamar Singh. This is the one with that 7-year delay from booking. In its 1/4/2016 ruling, the NCDRC found AWHO guilty of a clear deficiency in service, and they used very strong language, calling the organization's conduct below the belt.
That's a powerful statement from a top judicial body.
It is. The core issue was simple. AWHO had failed to deliver the property on time, and their welfare mandate was no excuse.
And the relief they ordered, the compensation, it set an incredibly high bar for accountability that echoed across the country.
It was a landmark ruling. The NCDRC ordered AWHO to pay delay compensation at a rate of 15% per annum simple interest.
15%.
15%. To put that in perspective for you, that is a highly punitive rate. It's far higher than standard bank lending rates, and it was much higher than the RERA interest rates at the time.
So it wasn't just about making the veteran whole, it was a punishment.
It was a punishment and a deterrent. It reflected the severity of the institutional failure and the incredible harm it caused to the beneficiaries who were waiting for their retirement homes.
And the most important part of that 15% figure is that it became legally set in stone, correct?
Yes. AWHO didn't just accept this, they challenged it. They fought it all the way to the Supreme Court. But the Supreme Court dismissed their appeal. They firmly upheld both the finding of deficiency and that high 15% interest rate.
So that cemented the principle, at the highest level, that AWHO is subject to severe financial penalties for its failures.
Exactly. But the courts didn't stop there. We have a later finding from the Delhi High Court, looking again at the Panchkula case in 2025, where they added another layer of punitive relief.
What did they do?
This was in the case of MD AWHO v. Cole Ashok Kumar Sood. The High Court once again upheld the findings of delay. It affirmed the base-level delay interest, though at a slightly lower rate of 8% per annum in this specific instance. But then they added something new.
A penalty on top of the penalty.
A powerful one. They added 12% per annum penal interest that would kick in if AWHO failed to pay the court-ordered compensation on time.
Okay, here's where it gets really interesting. The courts are basically making it clear that not only will you pay for the delay, but you will pay even more for trying to delay the payment itself.
It removes any financial incentive for them to drag things out with more appeals or to just stall on writing the check. The court was sending a message. The time for games is over. Pay what you owe and pay it now.
A mechanism to force compliance.
Exactly. Now let's shift to the RERA authorities, because they're also coming down hard on AWHO. We have significant rulings from the Tamil Nadu RERA in 2023.
And these cases really focused on RERA as a specific protective law for homebuyers.
Yes, they did. We looked at two important cases, Shinmugavlu K and Prem Abhilash Chandran. In both, TNRI found AWHO liable for delays of over 3 years. For instance, a unit promised in late 2014 was delivered in early 2019, a huge, damaging delay.
And what was the RERA calculation for compensation? How did it compare to that 15% rate?
RERA law has a more standardized way of calculating this. In these cases, TNRA awarded interest at 9.30% per annum.
Okay, so a lower number, but still significant.
It is. The rate is calculated based on a formula. It's the State Bank of India's lending rate, the MCLR plus an additional 2%.
Can you just quickly explain what that means, MCLR plus 2%?
Sure. The MCLR is basically the minimum interest rate a bank can charge for a loan. By tying the compensation to that rate plus a bit more, the RERA authority ensures the penalty is always relevant to the current economy and slightly higher than the cost of borrowing money. It's a smart, dynamic way to ensure the penalty always has some bite.
And crucially, the TNRA rulings went beyond just the financial loss. They recognized the human cost.
Yes, and this is so important. In both of those cases, the authority awarded an additional 1 lakh rupees, that's 100,000 rupees for mental agony, on top of litigation costs.
So they're saying the damage wasn't just to the veteran's bank account.
They're saying the stress, the uncertainty, the emotional toll of fighting this for years, that is a separate and compensable harm. It shows a level of judicial empathy that's really powerful. It's not just about the numbers.
So you have severe penalties from the Supreme Court, punitive interest from the high courts, and now compensation for mental agony from RERA. The message from the judiciary couldn't be more unified.
And that unified message often had a class-wide impact. The courts didn't just rule for one person. They often extended the relief to everyone in the same boat.
Can you give us a specific example of that?
Certainly, in one of the NCDRC orders for a project in Coimbatore, the relief, which included interest compensation and limits on cost increases, was explicitly extended to all members of that housing scheme.
Not just the people who filed the case.
Everyone. And even more directly, in the Pune Consumer Court case, the order was for AWHO to pay 85,000 rupees in damages to each of 52 different analyses.
52 people. That adds up.
It totaled over 44 lakh rupees in damages for just that one project's failures. And that kind of mass remedy is the court's way of saying, this isn't a series of individual mistakes. This is a systemic failure that affected an entire group of people.
The judicial record really is a powerful indictment. It paints this clear picture of an organization whose failures cost its own beneficiaries dearly, financially, legally, physically, and emotionally. The courts were forced to step in and basically correct their governance.
They had no other choice.
Okay, so we've established the failures and the consequences. Now we need to look at AWHO's defense. How did they justify their actions in court? Because they consistently tried to use their welfare status as a shield.
They did. And their legal strategy was remarkably consistent, which to me suggests an institutionalized approach to litigation. It didn't matter if they were in a court in Delhi or a RERA forum in Tamil Nadu. The arguments were the same.
And the main one, the cornerstone of their defense, was the no profit, no loss argument.
Tirelessly repeated. Their argument was essentially, look, we are a welfare organization. We don't make a profit, so you can't impose these huge commercial level penalties on us, like 15% interest. It'll destroy our ability to operate.
And how did that go over with the judges?
It was uniformly and definitively rejected every single time. The courts made it clear that AWHO's internal financial model, whether it's no profit or not, is irrelevant to their legal obligations.
The law is the law.
The law is the law. They ruled that when AWHO builds and sells homes, it is acting as a promoter and a service provider. And that means they have to follow the same rules and meet the same standards as any other builder in the country.
What's interesting is that they kept using this defense even after the Supreme Court shot it down in 2016. It sounds a bit like institutional denial.
It's a mix of institutional inertia and, I think, a calculated legal risk. Even if they knew it was a losing argument, it was the only unique argument they had. Maybe they hoped it would at least reduce the final penalty or get some sympathy from a judge. But the consistent rebuttal from the courts shows this was just a pattern of trying to misuse their identity to escape accountability.
Beyond the welfare shield, what was the next line of defense?
Shifting the blame. This was their go-to strategy for explaining delays.
Right, the contractor disputes.
Exactly, blaming contractor disputes or external things like mining bans or slow government approvals. They were constantly trying to argue that the delays were unavoidable, that it was all force majeure.
But as we covered, the courts completely dismantled that argument.
They took it apart piece by piece. The courts consistently ruled that your relationship with your contractor is your internal business risk. You, the promoter, are the one responsible for hiring good people, managing them, and making sure the job gets done.
A multi-year delay because you couldn't manage your vendor is not an act of God.
It's a reflection of your own procedural flaws. It's a failure of project management and oversight. The courts refuse to let AWHO hide behind their contractor's performance.
Okay, so that's defense number 2 shot down. What was the third pillar of their legal strategy?
The post-handover evasion. This was a clever one. They would argue that once a veteran had finally taken possession of the apartment, even if it was years late, their right to claim compensation for the delay was gone.
How did they figure that?
They argued it was moot or irrelevant. The suggestion was that by accepting the keys, the homeowner had implicitly accepted the delay and waived their right to complain.
And I'm guessing the courts didn't buy that one either.
Not at all. The RERA authorities and consumer forums were very clear on this. They confirmed that your right to get interest and damages for the financial injury you suffered during the delay. That right does not just vanish because you finally got your keys.
The injury already happened. The years you spent paying rent and an EMI at the same time.
That injury has to be compensated separately from the final act of possession.
So if we connect all these dots, AWHO's consistent use of the same 3 failed defenses over and over again, it really shows something.
It shows that the legal battle wasn't against isolated mistakes. It was against an entrenched, institutionalized refusal to meet their basic legal obligations.
It speaks volumes about their internal governance. Instead of seeing these court rulings as a wake-up call to reform their practices, they chose to just keep fighting their own beneficiaries in court, using the same losing argument.
The cumulative weight of all these judicial rejections, it stands as a final and necessary condemnation of AWHO's procedural and ethical failings.
So let's bring this deep dive to a close. Let's synthesize this comprehensive record we've walked through. And the picture that emerges is, well, it's unambiguous.
It is. This is not a story of a few isolated mistakes or some unavoidable construction delays. The evidence we've seen demonstrates unequivocally that AWHO's conduct is a pattern of institutional, widespread procedural failure.
The violations are not the exception, they're the rule. We've seen them spanning geography, from north to south, across years, across different types of projects.
And they're entrenched at every level. They're in the fine print of the contracts. They're manifested in those chronic delays that stretched for years. They're realized in those terrifying structural failures that led a court to order demolition. And they're confirmed by that administrative negligence that left veterans without proper legal title to their own homes.
The key takeaway for you, the listener, from all this, is the legal reality the courts have hammered home. The documentation proves that AWHO maintained practices, from tentative costs to as-is handovers, that were repeatedly and systematically deemed illegal, unreasonable, and unenforceable by every level of the judiciary.
The courts were essentially forced to become the ultimate governance mechanism here. They had to compel AWHO to comply through these severe financial penalties, that 15% interest rate, the class-wide damages, and that truly drastic order to demolish and reconstruct a building. This wasn't a gentle course correction, it was a structural intervention.
Which leaves us with a final provocative thought for you to consider. And it builds on this idea of reform and scrutiny for organizations that operate under the banner of welfare.
Given everything we've seen, the fact that courts had to provide class-wide relief, that they had to impose such severe penalties, that they specifically recognized the institutional intent behind AWHO's behavior, a core public policy question really emerges.
Which is,
should organizations with such a critical, non-commercial, welfare-based mission face more than just financial compensation when they fail this badly? Is money enough? Or should they be subjected to something more, like punitive governance-level audits or direct regulatory mandates to ensure their mission is fundamentally restored?
to guarantee that the people who serve the country are never again harmed by the very organization that was created to protect them.
It's a powerful thought on the future of oversight for these kinds of trusted, welfare-based organizations, and it forces us to reflect on the nature of accountability when an organization designed for protection becomes a source of profound risk.
Thank you for joining us on this deep dive.
We'll see you next time.